seek the benefit of the federal bypass trust to shelter whatever money they could from the estate tax. And under the construction that you have alluded to, where there was no requirement to create the marital decedent's trust and B and C, then wouldn't it also follow that the estate is therefore is not able to achieve the federal estate tax shelter, because there was not created a bypass trust, which was intended in the language of the original trust instrument.
Right. Mary Donkin had a choice. She could go, which was more important to her, saving those federal estate taxes or preventing litigation among family members. She made the choice to take steps to prevent litigation among family members. She did not create the subtrust. She amended the trust to give greater discretion to the trustees and to add a second no contest clause. And the beneficiaries have admitted that prior to her death and taking those acts, she was taking steps to prevent litigation against among members of the family.
Well, let's assume that after the first spouse's death, Mary hypothetically met someone else, was romantically involved, and amended the trust to leave the entire trust, the entire family trust, to this new friend. Did she have the power to do that?
Well, yeah, until the trust was not irrevocable, until those sub-trusts were created. That's what the language of the trust says.
Isn't the very purpose for these trusts, family trusts, to make sure that the decedent's half ends up with his children, ultimately?
Well, and yes and no. I mean, every family's different, and there's different degrees of trust. I mean, I draft a lot of these trusts, depending on the trust in the marriage. Some spouses say, I don't care if I have control over the assets after I die. I trust my spouse to take care of my children. Some say, I want to have control. When I die, I want to know that my assets are going to my kids. So, I mean, you can't really generalize about that. Every family situation is different, especially now that the whole concept of family is really
But counsel, I mean, let's not talk about trust in general. Let's talk about this trust. I mean, I'll read you the paragraph that follows the one that we were just talking about. It says the survivor's trust, right, shall remain revocable during the life of the surviving settlor. Now that sentence is nonsensical on your interpretation because the surviving settlor would have died already. So what life of the surviving settlor is there to speak of if we're waiting for the second spouse to die before creating the subtrust?
Well, then it's irrevocable when it's created.
This doesn't even pass common sense, counsel.
Well, I mean, the trust is not a model of clarity, and you can take different interpretations. I think, as I've studied that trust, I think it's set up so that it can go just what it says either way, and it will function either way.
So the trust instrument indicates that the marital decedent's subtrusts, particularly B, the bypass trust, and I believe C is all the residual. Also, it said that the distribution of those assets should be made upon the death of the second as soon as practicable. And that was the distribution paragraph that was in the original trust instrument. But Mary's Second Amendment, which allocated, which was a different allocation scheme, republished that paragraph when it also said at the same time, in conflict with the immediate distribution of the marital trust's assets as soon as practicable. It also said, in conflict, it seems to me, that the trustees can decide when, basically, at their discretion, to allocate the assets. I see that as a complete conflict with what the original trust said. How do you reconcile the conflict?
About when they allocate the assets or when they distribute them?
About the language of the second trust amendment when it republished the original trust instrument.
Well, the language of the Second Amendment obviously gave the trustees a lot more discretion about how and when to distribute the assets. But I think you need to take the clause that you're referring to about distributing the assets as soon as it's practicable. You've got to look at what comes before that. Just before that is the provision that says allocation of trust assets. And the allocation of trust assets says that prior to even allocating the trust in separate shares, there is a non-discretionary obligation that the debts and obligations of the trust be paid. Now, when the trustees took over in 2005, the trust was involved in litigation. There was a family member who had fraudulently tried to take 2 of the trust properties. They were involved in that litigation for a couple of years. They were successful. They recovered the properties, and they ended that litigation with debt from the litigation expenses. So the debts and obligations were not paid. The beneficiaries filed the first 21320 petition against them before that litigation even ended. So that litigation ended, they were saddled with debt, and then we go into the 21320 litigation, which has incurred additional debt and has also raised questions about the identity of who the beneficiaries are under the trust. So that's a non-discretionary condition to distribution. If you look at the structure, the paragraphs that precede that, there's a section of the trust called Allocation and Distribution of Trust Assets. And it says, and the paragraph that you refer to about distributing the assets as soon as practical is in that section. It's preceded by a number of sections that indicate that the trustees indicate that there is not an intention, indicate that the trustees contemplated ongoing management of the trust assets. It says, upon the death of both settlors, the trustee shall hold, administer, and distribute the assets as follows. It has a section on support and education. And it says that prior to final distribution, that the trustees can make distributions for the health support, maintenance, and education of any beneficiary. It talks about extraordinary distributions that can be made as incentives for beneficiaries. The language in this trust is very similar to the language in the case of Weinberger versus Morris.
I'm not sure in all of that discussion of the trust that we're familiar with that you have answered the question of the conflict between the allocation scheme in the Second Amendment and the distribution scheme in the original trust.
Well, the distribution scheme stayed the same in both documents. It's when the assets don't get distributed until they're allocated. And
so allocation and as soon as, in the discretion of the trustees in the Second Amendment, you're saying is consistent with as soon as practicable under the marital decedents trust distribution language.
No, again, distribution is after allocation. Allocation is subject to a number of conditions. For example, payment of the debts and obligations of the trust. And just preceding allocation is all this language indicating that the trustees have ongoing management powers prior to the final distribution.
Just for my assistance, does all this relate to whether the beneficiaries violated the no contest clause?
Yes, it does.
Did I understand you to say that you're not relying on the no contest clause?
Well, we're not relying on the no contest clause with respect to their claims, all these claims of abuse. The accountings were improper. There was improper compensation. None of those claims, we're not saying they can't bring those claims. There's just 3 claims. They're demanding immediate distribution. We're saying that that's contrary to the language of the trust. They're saying that...
contrary to the substantive direction of the trust.
No, contrary to the intent of the trustors with respect to distribution as expressed in the trust. The Court of Appeal found that their claim that Mary failed to set up the subtrust was a contest, and that it was contrary to the intent